Thank you. Please be seated. This is a time set for oral argument in our case number CACV 15-0749. Gerald and Janice Freeman versus Town of Cave Creek et al. Each side is allocated 20 minutes for argument. I may look to the left side here to see if you've got an allocation agreement, but or if one person is speaking at the microphone, or if you haven't yet worked that out. So
I will start and speak very, very quickly and reserve time for Mr. Artigue.
It is completely up to you, other than you get 20 minutes collectively, okay? I just want to make that about as clear as I can. Appellant has 20 minutes as well. You may wish to reserve a portion of that time. If you do wish to do that, you'll need to keep track of your own time at the clock in the podium. Out of respect for counsel, I would ask those in attendance to make sure your cell phones are off so their presentations are not interrupted. We have reviewed the briefs. We've conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind as you make your presentations to you. I also would remind you that our proceedings are being recorded. They'll be posted to the court's website and then to YouTube. So as you begin your argument, please, if you would, state your name and the party that you represent. With that, let's hear first from counsel for appellants. Mr. Mahaffey, is that a close pronunciation?
Very close, Your Honor.
All right.
Steve Mahaffey, yes.
Very well.
Yes.
Please proceed.
Thank you, Your Honor and Your Honors. I'd like to introduce let you know that my clients are actually in the courtroom. Jerry Freeman is in the front row, and his wife seated behind him there. As I think through this case, and I know you read the briefs, so I don't simply want to recite the briefs to you, but I want to talk to you. I want you to understand why you should rule in my favor, in my client's favor. And I think the thing that concerns me most about this case, and what should concern you most about this case, we have to hearken back to our first-year property class. And what we learned in first year... I know, nightmarish perhaps.
Meets and bounds.
All of that stuff. But what we learned is that when you buy property, you get certain rights with that property. And what concerns me the most is the erosion of those rights that the ruling has brought on. And what erosion am I talking about? I'm talking about, Your Honors, essentially allowing a private citizen, Cahava or Morningstar, to give a government the right to invade the Freeman's private property rights without the benefit of takings law, without the benefit of eminent domain protections. That, to me, is the core of what's going on in this case and the most bothersome. Because this isn't simply about Cahava and Freeman's. We talk about the restatement, and I'm sorry, I want to reserve 5 minutes. I don't know if I've mentioned that to you.
Okay.
We talk about restatement, and the restatement talks about relationships between the servient tenement and the dominant tenement. And we can look at all of that and apply it, but none of that is necessarily so because we have a state actor. And if I could have shown that the state actor and the private party were in conspiracy, then I probably could have bootstrapped this into a takings case. But I didn't have the facts at the time. I don't think they still exist today. Perhaps counsel will let something loose in his argument that would make me think otherwise, but right now I don't have that. So what do we have? We have a private property servient tenement who wants to grant a public entity the right to use a dominant tenement's easement.
Well, if we take it out of the government and say that another property owner would do the same thing, would there be any prohibition to that?
Well, I think you still have the same analysis. I think you get down to unreasonable interference, and you still have the same analysis of, does the third party, under the terms of the deed, does the servient tenement have the right to grant whatever use that is? Let's say, for example, does the servient tenement have the right to sell a parcel of land and let that new owner use the actual roadway? Well, I think yes is the answer to that question. But that's not what we have here. Because in that case, you would have a contiguous landowner who needs access and is going to simply use the same roadway that we use. Now we have, how much are you going to contribute for the maintenance? Which is a different question, not before you today. So that question is not what's before you here. What's before you here is simply, can we take a private, and I say exclusive, non-exclusive, I read the restatement, 3 levels of exclusivity. And I believe that we do have some sort of private roadway. It dead ends at my client's property, and they're taking my client's private easement to use for public purposes. And the private actor is doing that. And that's why, for me, that is the erosion of my client's property rights. If you look at why the trial court, I think the trial court ruled on the declaratory judgment action. We all would agree that his words were denied. I'm not ruling on that. But what he did do by ruling that the town can build the trail, he tacitly ruled that a private party, Cahava, has the right to grant a public easement over the private easement. He tacitly ruled that. He had to, right? Because he prohibited the town from building the trail unless and until they comply with these 3 requirements. So he tacitly ruled that Cahava does have permission, does have the legal authority to give the town permission to build the public trail over the private easement. And so that's the abuse of discretion.
Yeah, I guess I have trouble with your words that Judge Talamonte is allowing the city to build a trail over your client's easement. Basically, it's a crossing in 2 places, and I don't see how that is. I guess I don't. I think that goes to whether there's a nuisance, and I guess I don't. I'm having trouble with your, because you're making it sound like he allowed them to use the whole easement. It's a crossing over in 2 spots.
You're if I may, size matters. Because your suggestion is that these 2 4-foot wide crossings are not that great of an impediment. For me, putting words in your mouth, but that's the suggestion. You recall a case, and I cited it in my briefing, the grant of a right to use a piece of property includes the last inch as well as the first inch. And so what we are maintaining, we do believe that there is a 100% prohibition from the public use of this.
So your problem is that the city is building this trail, not that it's being used. I mean, if it was a private property owner, you said that would be fine. Your problem is that it's because the city is building a trail through these 2 points in the easement. Is that it?
Well, I think if let's say, for example, Cahava was going to build a track around that they could exercise on, and only people who were associated with Cahava would use it, and they would cross that. I don't know that we're here. I don't know that we have as big a problem with that. What we're talking about is the town intends to invite 10,000 people to use this trail.
So so I'm correct. Then it's the city, the use of the city using this crossing that is what's bothering your client.
It's the public at a level. Yes, it's the public use of the private easement at a level. The question then, the analysis dovetails down into unreasonable interference. And
what's your best evidence of unreasonable interference?
Well, I suppose the best evidence of unreasonable interference is that the court ruled there would be unreasonable interference unless you take these 9 factors into account. So the court did issue a permanent injunction against the town. And the difficulty that I have with the ruling is that Cahaba could make this trail. There's no court order that prohibits Cahaba from making this trail. We know that the town, or we believe the town has budgeted about $161,000 to build this trail. Well, let's say someone donated that money to Cahaba and said, well, you guys go build the trail and the town won't worry about it. You guys just do it. And then ultimately Cahaba gives that to the town. Well, the problem...
So you're worried about a conspiracy?
No, I'm not.
Well, because it sounds to me like if that's what you're worried about, then you will have another cause of action down the road. But based on what's in front of us right now, I guess I'm having trouble.
I don't
So
believe...
I just want you to explain it to me.
Sure. I don't believe that Cahaba could build a trail and invite the public to use it. I don't think Cahaba can do that. Okay? And therefore, why can the town do that? The town's stated purpose is to let the public use it. I mean, they're out there. They want the public to use it. They intend for the public to use it. They're going to sign it. They're going to tell everybody about it. You saw the testimony. I think Bambi Mueller testified that this is the east-west connector that people have been dying to have. So we absolutely know the town intends that it will be used by the public in a great way. Give us the human factors portion of Exhibit 39 of the trial. The human factors say horse riders will take the path of least resistance. Well, so again, we're down into the unreasonable interference. But the clear language, in my view, the clear language of the deeded easement doesn't allow them to build this, doesn't allow Cahaba to build this.
What is the language that you're relying on, the easement?
Well, it's the language that I've cited in the brief, that the roadway as it existed in October 2nd, 1969.
Well, the roadway as it existed in 1969 wasn't paved. So in actuality, your client has violated the easement. If we were to take that to its logical conclusion, wouldn't we?
Actually, the road's not paved. It's got quarter minus gravel.
It's changed since
But
69.
it's changed since 1969.
Actually, it's not part of the record. Anecdotally, I'll tell you, I actually deposed in another case the daughter of the Daggetts, and she testified that the road is actually not as good today as it was back when her parents built it.
But it's different.
So, well, the location I don't believe is different.
You understand my question?
Yeah, in quality, according to Margaret Licasati is her name. According to her, it's actually diminished in quality, if you will. But at quarter minus, I believe it did have quarter minus back then. It went through a period of where...
Let me restate it. So it's your position that the roadway is exactly like it was in 69 or not?
Well, using that word, I would say or not.
Okay.
How it's
Thank you.
different, I don't know. It's not paved, though. I do know that. And it's never been paved. So then to me, the analysis gets down to the restatement. And is public use unreasonable interference? And under the comments to 4.9 of third restatement of property under servitudes, I think there's no question but that public use is prohibited because we don't want to get into these qualitative arguments of will the public really use it? Are they going to use it too much? And so that is why I think that this case needs to be, let me back up. The Cahaba indicated that he was surprised that I didn't ask for a retrial or something of that sort. I don't know the facts would change on a retrial. I mean, this, to me, is a legal question. These are legal questions that you are easily able to direct the trial court without the need to go back and take more facts under the restatement.
How are we to know whether we will have a little public use or a lot of public use based upon the trial record?
I don't know the answer. I don't know that you heard.
Okay. You know, I appreciate and I can see the vision and I understand, but on the record that is here after that trial and what the Freemans want to prevent, okay, which is lots of people using those crossings and creating some problem by the invitation by a public entity, but we don't know if it's going to be a little, we don't know it's going to be a lot, whether it's going to be just on Saturdays and Sundays and holidays, or, you know, you're going to have Boy Scout troops, you know, Boy Scouts tramping all over the place, and so that's why the question.
Well, we do know that there are bike rides at night with lights on. The testimony was that. We do know that Mr. Freeman testified to having 1,200 plus trespassers on a regular basis who come up his road to try to get to other places. So the idea, maybe your concern is I'm speculating and you don't want me to speculate.
Well, but we can't speculate in terms of what is the effect of the court's ruling on something that isn't contained in the record yet.
Yeah, I mean, that question almost gets back to should he have issued an injunction at all? And I don't know if you're struggling with that issue. I hope you're not. But really, that's actually, you should be, if that's to be consistent.
Well, but, you know, that's, you know, you're saying the court got it wrong, and please do something, and, you know, the court listened to the evidence, you know, had the exhibits, made its findings, and told the town, you can't do anything unless you do these 9 things. And you want us then to go a little further and say, heck, you can't even do that because of the impact that might be caused if they were to do that. And we don't know the extent of that potential impact.
Yeah, are you suggesting then that the entire case was premature?
I don't know what I'm suggesting. I'm just I'm listening, you know, having read the briefs and now listening and understanding better, you know, that it's the issue with the town and a potential taking and future use and how that might grow from a trickle to a flash flood and continue. But how do we then resolve that based upon the record that the trial court had by saying, hey, I'm going to let the town do this under these 9 things that Mrs. Freeman has suggested, and then that's okay. But, you know, because the next issue is, you know, how much is too much? How much is too little?
Well, and that's why the restatement says we prohibit it all, so we don't have to do those analyses. I'd like to reserve some time, and okay. Thank you.
Thank you, Counsel. We'll look to Counsel for Appellees. Who's going first?
Jeff Murray on behalf of the town, Your Honor. Thank you.
Please proceed.
And let me just, excuse me. I will indeed, as probably every lawyer says, try to be brief. And the reason why I think I can be brief is we struggled with the same questions that this court has struggled with. They are asking for relief based on evidence that's just not in the record, and that's what we really struggled with. I think I can summarily dispose of the taking argument. There are 2 kinds of takings. There's one where there's physical occupancy, and there's one where there's you pass an ordinance, pass a law, and you prohibit all use of the property. That hasn't occurred here. As Judge Orozco, I appreciate, pointed out, much of this case has been tailored from the appellant side to say we're trying to use the easement. And in fact, The town went out of its way to not use the easement. The town went out of its way to limit and diminish any potential crossings of the easement. And that's where we find ourselves, literally a 4-foot trail crossing an easement that is not the same today as it was in 1969. I think in their papers, certainly in their complaint, they indicated that easement was 8 foot. That's not in the written language of the easement. The easement just says you have a right to use the road as it existed in 1969. There's been no evidence. There was no evidence at trial even what that looked like. So it's very, very difficult for them to cite to the Squaw Peak case and for them to cite to these out-of-state cases and saying, hey, you are prohibited from any use of the easement, when in fact what the restatements say is that Cahaba, as the servient estate, may in fact let others use that same easement so long as there's not unreasonable interference.
What is your response to the Freeman's argument that this is because Cahaba is granting the use of the property to the town, that somehow that is different, as if Cahaba was going to use the easement himself, but because he's granting it to the town and hundreds of people are going to cross here?
Well, I don't think there is a difference, to be honest with you. I don't think there is a difference. I think what the restatements say is that Cahaba can do what they want with their property so long as they don't unreasonably interfere with the existing easement. Now, Mr. Mahaffey in his presentation to you all said, well, there's going to be 10,000 users. You've looked at the trial transcript. There's not one piece of evidence in there to suggest that. And in fact, there's no evidence to suggest how many people will use this. The only evidence we have is the conflicting testimony between the two dominant estates. Mr. Freeman testified that there were roughly 1,200 to 1,400 trespassers a year. Now, keep in mind, there's not even a trail there. We haven't even constructed a trail. So to the extent he then testified that at least half of those are equestrians, perhaps the town's trail will take those folks off of his roadway easement and let them pass freely on a trail. That's the only evidence we have, followed up by Mr. Sorchek's testimony that said, oh, by the way, I've seen 2 to 3 since I've lived there for the last 10 years. So wild swings in testimony, but that's the extent of the record. There's no testimony or evidence that says, here's how many people are going to use the trail. In any event, the cases, I think, and the restatements, the cases we cited.
So let me ask you, what would that evidence look like?
There would have to be some kind of, Your Honor, there would have to be some kind of projection. There could have been testimony. They testified that there were 2 guide stables down the road near Spur Cross. They could have brought in one of those folks and said, yeah, we think based on our business or our clientele, we're going to run X number of trips down this trail.
But you're not saying, are you, that Mr. Freeman was unable to testify as he did properly at trial, are you?
Oh, no. Mr. Freeman testified as to his opinion and what he believes he's seen. My simple point is that testimony was then rebutted by his neighbor.
I understand your position that they're conflicting testimony.
Right, right. That's it, Your Honor.
Okay.
That's it. Nothing further.
Thank you.
I really do think I've got pages of notes. I've got cases. I've got restatements. Certainly, I will wrap this up very, very quickly. This is not a takings case. Never has been a takings. It's not an unreasonable interference case. The town is not proposing, and there's testimony by both Ms. Mueller and the trail designer and constructor, that this road will look identical once the trail is connected on either side. We're not touching the road. So there's no permanent physical obstructions being constructed. There's no 6-inch curbs like the Squaw Peak case. Nothing. And in fact, the signs are going to be on the trails. The signs aren't going to be on the road. So whatever was out there in 69 is what he is entitled to, and we're not touching the road. And I believe the town will tell you that they intend to assume that whatever's out there today is what was out there in 69, and we're not touching it. We're simply crossing it. Period. End of story. I think the cases, I think that the restatements are quite clear, and at the end of the day, we certainly could have filed a cross appeal, but there is so much discretion lodged with the trial court. The trial court heard the evidence. He heard 3 days of evidence. He heard 3 or 4 expert witnesses testify. He took all that into account, and he made a decision, issued an injunction, and said, hey, town, you can do this, but you got to follow these 9 steps. And as a little bit of a side note, I will tell you, the case got sidetracked, and the judge noted that. Many times the judge said, what are we here for? I thought this was unreasonable interference. Now you're parading engineering experts and trail builders in front of me. Why are we doing this? Well, we're doing this because then the appellant, or previously the appellant, had challenged the feasibility of the trail. So now we had to not only come in and say we're going to cross it in 2 limited places, but here's how we're going to build the entire trail. Judge Talamonte, the trial court, took all that into consideration and said, okay, you're not going to unreasonably interfere if you follow these 9 steps. You stay out of their way, and you make sure your trail is stable so you don't affect the structural integrity of the road. That's it. That's what the town is prepared to do. I think that the pleadings stand for themselves. The papers in front of you stand for themselves. I think the case law is fairly clear. I think we've clarified it. I think Cahava has clarified it. I don't have anything further. If you all have questions, I'd be happy to answer. Thank you.
Counsel.
Good afternoon, Your Honors. Cameron Artigue on behalf of Cahava Springs. The 2-word phrase on the tip of my tongue that I haven't heard yet this afternoon is clearly erroneous. Obviously, the standard under Rule 52 for findings of fact, the defense filed a Rule 56 motion before trial, and the plaintiff said, oh no, there are fact issues here we have to take to trial. And we did. And, Judge Portley, you asked, how could you possibly get a grip on the degree of traffic and how much of an interference would there be, how many people would be likely to use this trail? That's what the trial was for. And the finding of fact was made that there would be no unreasonable interference. That's a factual finding. Okay? It must be affirmed unless it's shown to be clearly erroneous, and it hasn't been. The only sort of interesting wrinkle on that I've heard is the suggestion that Judge Orozco's followed up on, that somehow if you grant an easement for a public use, it's more likely to cause unreasonable interference than if you grant it for private use. That's not in the restatement. That's not in any case I've seen, and it doesn't make any sense to me. Some public uses are going to have a high volume of traffic. Some are going to have a low volume of traffic. You could have a public use in the middle of nowhere where there's 2 people a year. You could have a public use and say, well, we'll have the Secretary of State come out and do the election canvass once a year in this easement, and that's the public use. Once a year. And so it becomes factual whether the second easement becomes an unreasonable interference. There's no per se rule against granting an easement for a public use. This is an appeal from fact-finding, okay? The second and final point I want to make is to follow up on Mr. Mahaffey's point about eminent domain. It's not an eminent domain case. But I think Mr. Mahaffey opens the door to exactly why the injunction that his client seeks makes no sense. Okay? The town of Cave Creek has the power of eminent domain. If the town of Cave Creek wants this trail, they can build this trail. Judge Talamonte cannot grant an injunction against the exercise of a legislative decision. He can't enjoin Cave Creek from filing an action in eminent domain. So think about that. What would it even mean for Judge Talamonte to enjoin my client from giving an easement to Cave Creek? Does that mean that if they file an eminent domain action, my client's not allowed to settle? Does that mean that if they file an eminent domain action, my client's not allowed to settle? Does that mean that if they file an eminent domain action, my client's not allowed to settle? Does that mean that if they file an eminent domain action, my client's not allowed to settle? Does that mean that if they file an eminent domain action, my client's not allowed to settle? that we have to litigate and resist as hard as we can? Because if that's the position, then the injunction will be absolutely contrary to public policy, which is, so let people settle things, let people work things out. And if Judge Talamonte said, no, Cahava Springs, you may not convey this easement to Cave Creek, what if they just sent us a demand letter and said, hey, Cahava, if we don't work this out, we're going to go to Superior Court and file an eminent domain action. They can do that. That's their sovereign prerogative. I mean, it would make no sense to grant an injunction saying no settlement before litigation, no settlement after litigation. This is going to have to be fought as hard as you can fight it. And so Judge Talamonte may have thought to himself, this injunction that I'm being asked to grant, it's easily circumvented. It's not really enforceable. It doesn't make a whole lot of sense. It's against public policy. And it's not really ripe. So, at the end of the day, if there's some kind of tort claim because people are interfering with the plaintiff's property interests, that's a tort lawsuit. Let them bring that lawsuit years from now, and we can litigate those issues down the road. For today, no abuse of discretion has been shown, no error has been shown, and I'd ask you to affirm, and I'm going to sit down.
Thank you.
Thank you.
Council rebuttal argument.
Just a few minutes left. I want to last first. The difference between the eminent domain law is money exchanges hands. I mean, that's the obvious difference, of course. Did the town offer to buy this from us? Absolutely not. We know they have the power of eminent domain. We brought that up early and often, and they chose not to exercise it. That's their prerogative. They didn't have to exercise it because they had a private property owner who wanted to give it to them. But the restatement talks about the relationship between the servient tenement and the dominant tenement. It does not talk about the relationship between a non-landowner, third-party public entity and the dominant tenement. And that's why this can't happen. Also, I looked back at the judge's order, the minute entry, which was filed on May 18, 2015. I know that's part of your record. And going to Judge Roscoe's point of how many crossings is too many crossings, according to Judge Talamonte, more than two is too many. As he specifically said, quote, also the non-motorized trail must not exceed the two proposed crossing points over plaintiff's easement without revisiting the entire issue of unreasonable interference, end quote. So,
I thought her question was different. Not how many crossings, but how many people or horses or otherwise use the property.
Then I misunderstood the question. But I do think that the judge indicated, and bear in mind, as the briefing states, we started this case out where we were informed that they were just going to use our easement all the way across the wash, and that's about at least a half a mile journey across the roadway. So there's been many iterations to the final one of two perpendicular crossings. And again, the restatement talks about how much traffic is unreasonable interference. Well, that's the whole reason the restatement in the comments discusses public use. We don't want to have to go there, so we don't allow public use. Additionally, the section 4.9 of the restatement, and under comment C, it states, quote, actions that make it more difficult to use an easement, that interfere with the ability to maintain and repair improvements built for its enjoyment, or that increase the risks attendant on exercise of rights created by the easement are prohibited by the rules stated in this section, unless justified by the needs of the serving estate, end quote. What need does a serving estate have to grant a public entity the right to use the property over the dominant tenant? They don't have any. If this didn't touch our easement, we're not here. We accept that Cahava can give permission to the town however Cahava wants to. But where that ends, the proverbial, you're right to yell at me ends at the tip of my nose. And that's where it ends. It ends when you're going to take and use my easement. You don't get to do that. If you want to find another way to do it, if you want to give them, let them go around, that's fine, but you don't get to use my easement. And that's what the law is. That's what the centuries of property law say, that the Freemans have the right to unfettered use of that easement, and that the servient tenement may not interrupt or interfere with that use unreasonably. And the restatement says that public use makes it unreasonable. I'm out of time. I apologize. I went over. I apologize.
It's just fine. Thank you, counsel. We appreciate your arguments today. We appreciate your arguments in the brief. You've given us much to think about. We will take the matter under advisement. We'll issue a ruling in writing in due course. Thank you. We'll stand adjourned until we set up for the next oral argument.